Well, welcome back to the Cordell and Cordell virtual town hall. I'm Scott Trout, CEO and managing partner of Cordell and Cordell. We continue each month for the last 16, 17 months to bring you this town hall where we address issues for guys before, during, and after divorce and all things regarding family law. And today is no different. We're going to talk about something that I think is fairly popular and probably even amplified during COVID, and that is the DIY divorce. You will be inundated with ads, on the web, you'll see these advertisements for DIY forms. So we want to talk about the pitfalls of DIY divorce, how to avoid it really, some of the things that you may need to know if you're moving through a DIY divorce and you think you've got the right forms and the right information. Really want to expose a little bit about some of those things. It's like being your own doctor and treating yourself. So you have to be really careful. So second half, as always, during our town hall, we want to take your questions live, and we'll do that sometime in the second half of today. You want to submit those via the Q&A section, where you can go ahead and post your question. Give me your first name, give me a state where you live, and we'll toss it to one of our panel Cordell and Cordell attorneys to get you answers. But as always, keep caution that today is really educational and informational, and we cannot give you legal advice even in the second half of the lightning round of questions section of our virtual town hall. The attorney-client relationship can only be formed when you come in for a consult or do a virtual consult, which we are making available throughout the country in any of our Cordell and Cordell offices, via Zoom, just like this, via telephone, WebEx, whatever form you want to utilize, or you can come in where you feel appropriate and safe to do so. But you can go to our website at cordellcordell.com or give us a call at 866-DADS-LAW to schedule that consultation. And that is really the best way to get the right advice for you. So would like for you to get a piece of paper out and take some notes for today. And this is intended for you to stimulate a conversation with an attorney. And as always, I talk about seeking an attorney who practices exclusively in family law is the best way to go, just like our attorneys do throughout the country, including the United Kingdom. And mentioned the question session in the second half. If you don't want to ask a question today, you can always submit it via email at townhalls@cordelllaw.com. Townhalls@cordelllaw.com. We'll either address it at the next virtual town hall in May, or we'll do it in our weekly podcast where we talk about this twice each week. If you haven't checked it out, you want to go in and check it and go ahead and subscribe to our podcast. It's the Men's Divorce Podcast, also Cordell and Cordell. You'll get updated each time we upload a podcast, and we're going to take about 15 to 20 minutes twice each week just to talk about topics that are important and relevant to guys facing divorce, modification, contempt, paternity, all things related to family law. Check out all the content that we have on YouTube as well, our YouTube channel. It is filled with all of our previous town halls and some of the all podcasts as well. I guarantee you'll find the topic you're looking for. And if not, give us a call. Send us an email. We'll cover that topic next month at townhalls@cordellllaw.com. So as I mentioned, we're going to get to the question and answer sometime in the second half. You'll want to submit those. I'll be watching the Q&A section. If you have questions right now, submit them. We'll get to those. I know we have some already, and we'll cover those as well. So let's get to introducing our panel of Cordell and Cordell attorneys that will talk about a DIY divorce today. Let's start up in Edina, Minnesota. Andy, welcome.
Welcome. Thank you for having me. I've been practicing since 2004 here in Minnesota. I've also practiced and licensed in Wisconsin, as the states border each other. Practice exclusively in family law, and I've been with Cordell since 2012, so I'm happy to be here.
Thanks, Andy. Let's go now to Miami, Florida, and Amanda. Welcome.
Hi, Scott. Thank you. My name is Amanda DePlang. I've been here with Cordell since 2014, working out of our South Florida offices in Fort Lauderdale, Miami, our Dayland Doral offices. And we've been doing exclusive family work here at our domestic litigation firm, as I did also when I was a paralegal before. So I have a lot of experience in the different aspects of the dissolution action and child support and paternity and what it takes to take the case that I offer here to our offices.
Thanks, Amanda, and continuing to bring you an attorney of Cordell and Cordell, where we kind of get across the country. We're going to go to Lincoln, Nebraska. Welcome, Megan.
Hey, Scott. Thanks for having me. So I practice in Lincoln, Nebraska. I'm licensed in Nebraska as well as the Ponca Tribal Court here in Nebraska. I have practiced exclusively in family law. for the last 5.5 years, as well as juvenile court.
Thanks, Megan. We're rounding out the panel for today where we talk about DIY divorce is Jared in Mississippi. Welcome.
Hello, my name is Jared Rayburn. I'm in our Ridgeland, Mississippi office, and I am in my 4th year with the firm, and I've been practicing family law exclusively for the past 6 years.
Great. Thanks, Jared. So now we're going to get to our topic today, but first let's take a real quick commercial break and we'll be right back.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
All right, let's get to the topic of the day, and that is the DIY divorce. You know, there are firms are advertised routinely to provide forms regarding a number of topics, whether it's wills and trusts or formation of corporations and family law. You can see it, and there's some caution. I can tell you that we often meet with clients that were potential the clients that come in with questions like that, and they have a form that they've downloaded off the internet. And we want to highlight some of the things that you need to be concerned about. And let's start with Andy. Andy up in Minnesota. You know, one of the things I think that is really apparent, and I think all of us have this experience when we talk about a DIY divorce, is you have to be really careful about the language that you're going to use, whether it be in the decree of divorce or the settlement agreement, the parenting plan, anything as it relates to that, because you know, there's a book out there that I really enjoyed. It's called Words Matter. And they do, especially in family law. And if you're using a form, I mean, the unique thing about family law, Andy, and I'm really curious to hear your thoughts, is that every case is peculiar and it has a certain set of facts and circumstances that require special language. And you have to be very careful about that language and think forward as well as backward about what you want to do. And so really, why is it that this language and the words matter in your decree?
Well, language really matters because it's a contractual obligation. And what happens to people is that down the road, there could be an interpretation issue. And nobody remembers what those interpretation issues are. And the problem with using kind of standard forms is they're one size fits all, and they don't really deal with specific situations in your case. Just as an aside, Minnesota has a form that they call it I can. In the practice, we call it I can't, because there's a lot of issues with it that people don't necessarily consider or think about. You know, one of the things that can happen is when you're considering and thinking about these things, you don't necessarily consider all the contingencies. You don't consider what the language means. And what that language means is a matter of interpretation. When you're trying to interpret something, you are then looking at it down the road. And really, you don't know what you don't know. So as a lawyer, we can help you kind of think through all those angles, think through all those contingencies. If you're doing it on your own and you're using the preset form, they'll put down a few contingencies, but it's kind of a select all type thing. Mm-hmm. And it's not sort of like diagnosing yourself on the web. You know, I've got a cost, so that must mean I have X. But you really don't know, and you don't know what you don't know, and that becomes a real big issue.
Yeah. I mean, I think it's really appropriate if for a DIY, if you have no kids, you have no real assets, and you're just simply terminating the marriage. That to me seems real straightforward, and you don't have perhaps tax liability or some sort of financial impact. But obviously, Andy, I got to believe that, and I have examples when you think about finances and you don't have clarity. The one that comes to mind, I'm curious what comes to your mind, is 401k. One of the mistakes I've seen repeatedly is someone downloads a form, and in that form, when you're dividing a 401k, it may have a blank. And instead of using percentages and then using language that says plus or minus any gains or losses, they may just say, I'm going to divide 50%, but that blank, instead of doing a percentage, they're putting in a dollar amount. And so what happens is, let's say you have a down day. Let's say I've actually had a client that came in that there was a specific dollar amount to be divided with at the time that they signed it. it was representative of 50% of the value, but by the time they came in and divided it, all that was left was her share. And so he got zero, and there was nothing we could do because the language wasn't, there was a problem with the wording. And I mean, anything dealing with finances, Andy, don't you find that to be problematic?
Very problematic. And I was practicing in '08, and if we remember that the market crashed, I think on a September Sunday, and there were Bear Stearns went under. I remember watching football, and we all came back in, and there was all kinds of problems. People hadn't put in plus or minus earnings or losses, and their accounts were essentially worth zero. And if you say she gets $50,000 of the 401k, and the 401k is now $50,000, that means you get $50,000. And I think most of us all anticipate the market's going to go up, or the house is going to appreciate in value, or those sorts of things in terms of finances. And it doesn't necessarily work that way. And then the problem is on enforcement, most states make it difficult to change that. So if you were in that situation where you didn't have appropriate language, then you're trying to change it, and the court's going to likely say no. Because especially like in '08, there was a whole slew of people that were put into this situation, so the courts it wouldn't be really sympathetic to you.
Yeah.
So that really puts you in a negative situation if you haven't considered all of the financial implications. And everybody thinks about things getting better, but there's always, roller coasters go up, they also go down. And I think that's the importance of language, to have that, because if it's going up, it's great. But if it's going down, then it's much more difficult, and you can really hurt yourself in how those assets are divided.
It would make our lives easier. And I think through this, if we just hit a button that says print for every client that resolved their case, and you don't have to, and every provision was standard, it's just not that way. And I'm thinking of taxes and whether or not the liabilities you have, or gains, or taking property that may have a tax consequence, but nothing is more important than custody. And if you're not very specific when it comes to parenting time, what is assigned to you. I mean, my favorite one, it was 15 plus years ago when the courts were probably not as attentive, was the parenting schedule shall be as the parties may agree. And, they all agreed at the time, and it was all, lovey-dovey, and I trust her. And lo and behold, they came back and they didn't have an agreement. And, now we had to file a modification. But joint legal custody, that's the one I always watch for. In these forms, it may say wife gets joint, or they have joint legal custody, but wife reserves the right in the event of a dispute to make the decisions regarding health, education, and welfare. That's where the language really matters in joint legal custody, right?
Yeah, I would agree with that. I think it matters, especially when there's a dispute. One that comes to mind is that I've had over the years that's really germane right now is vaccination. If you have wife has the ability to make the decision, and one party wants vaccination and the other doesn't, that you basically are in a situation where you've given de facto legal custody.
Yeah.
And there also needs to be some definition or discussion about shared values in most of these contracts. So for instance, in the situation where, let's say, one person believes in vaccinations, and I'm just using that because of COVID, and one party doesn't believe in vaccination, there really needs to be a methodology laid out. How are you going to resolve it?
Yeah.
Because if you lay it out and you have joint legal custody and one of you disagrees, how would you resolve that, and what would that look like?
And I think, if anything that COVID has taught us is that there are more provisions that need to be put into parenting agreements when it comes to pandemics, and what the obligations of the parents are in terms of ensuring that they exchange custody. Where can they go? Are they allowed to relocate? Whatever it may be. And some of these pandemic provisions that now we're having to put in are very unique. You will not find them in forms. You won't find religious holidays for whether it be Jewish or Muslim. You won't find those specifics where you may celebrate particular things. Relocation. Some of these forms don't prohibit relocation, albeit states have statutes, but you want to be specific about custody, right? I mean, these are the things that honestly, a DIY divorce, make great intentions, but the result could be disastrous.
For instance, kind of dovetailing off your comment about relocations, For instance, in Minnesota, you could have someone move to Hudson. You'd have to have court permission, and that's 20 minutes or 40 minutes from Minneapolis. But that same person, if you didn't have specific provisions in your decree, could move to International Falls, which is a 6-hour move. And I think everyone would agree that would be more difficult. So that those are kinds of things that you don't think about. And the other thing to think about is these agreements, it's like a stress test when you're on a treadmill at that point. You do the EKG. So when you're actually having these agreements looked at, there's some stress. Everything isn't lovey-dovey. So without clear language that promotes fighting, and without the clear language and the fighting that's promoted, it becomes, the results are more uncertain.
Yeah.
And really the beauty of having contractual language that's solid is it prevents those problems, because there's going to be changes, there's going to be disagreements. My thought always is when people repartner, especially, that produces a lot of conflict in many cases. And if you don't have clear contractual language, then you have a third party interfering, and then your parenting time becomes more difficult. And with contracts help prevent that.
Yeah, I mean, I think we could spend an hour talking about the provisions that I can think from the top of my head as it relates to custody or specificity, the definitiveness of language. It's a lot where we're resolving cases. We're just sitting thinking, okay, what am I thinking about? Well, right of first refusal, those types of provisions that I'm just telling you, I've seen, they're not in these forms. They're not there. You need them there. How do we handle taxes for the tax year 2021? Whatever that may be. What about stimulus money? That's not going to be in those form agreements. How's that shared? Don't make assumptions that you're going to split it just because it's in both names or whatever it may be. You've got to ensure that there's concrete language that you can back up, including a provision for attorney's fees in the event that someone fails to comply. As one of my, necessary provisions is, hey, in the event that wife fails to do X, you shall receive fees. Take that kind of discretion out of the judge's hands and make it definite. So, Andy, thanks. Let's go to Amanda. Amanda, one of the things that a lot of people have questions on, they may have done a DIY divorce in their history. They may have done it uncontested, downloaded a form, and now they're questioning themselves. Now, how do I modify not only custody, child support, maybe spousal support? Maybe you can walk us through the standards for modification of each one of those. Let's just talk child support to begin with, and then we can talk about kind of maybe some of the things that you would try to ensure if you're in the middle of a divorce and you want to set yourself up for a modification, what you may want to avoid. But let's talk about the standards of modification first.
Sure. So people often think if they don't like something that was originally agreed to through a DIY divorce, or the lack of language and clarity, is that, oh, I'll just modify it. But it's not that simple. There are standards, there's things you have to prove for a modification to be successful. It can't just be, oh, I didn't like it at the time, or I don't like it anymore. So in Florida, child support can be modified when there's a change of circumstances. So what does that mean? With regards to child support, it's generally going to be a change in income. A lot of the things that we see in these DIY divorces and agreements, when there's multiple children, oftentimes there's not what we call a step down for when each child ages out. So if you have 3 kids, your first child ages out, graduates high school, or turns 18, you're stuck now paying child support for the 3 kids, even though one is now an adult, because the agreement didn't contemplate that reduced child support for the 2 leftover kids. Same thing with the middle child. Once the middle child graduates high school or becomes age of 18 or emancipates in any other way allowable by law, then again, you're stuck paying child support for multiple children when you only have 1 minor, which is what you're legally obligated to pay. So one of the things that we look at when we do these child support calculations and these agreements is what you said, Scott. We're looking at the incomes. We're wanting to set up for a future modification. We're wanting to make sure that the incomes are accurate so that in the future we can modify it if need be. But before we even get to a modification on income, we want to make sure that the current agreement lasts you in the event there's not a change of income and we're just dealing with, we have consistent income, we have steady income from both parties, they've stayed around the same, so there may not be a huge modification in the short period of time, where the kids age out, but we've already had all that contemplated. So we know when the first child ages out, we're already having that second obligation, which the reduced amount in the agreement. And the same thing with the other child. These forms and these settlement agreements that come from the courts that are offered don't have any of that language. And oftentimes the courts just look for one child support calculation to be done, which is going to encompass all 3 kids in my example. So they won't even look or require you to have the child support for each child as they age out.
Yeah, I mean, it's daycare is my great example of these DIY forms, especially in Missouri, because when you're calculating child support, daycare gets lumped into the chart, what they call Form 14. Now, there is a provision that says you can deviate from the chart when it's unjust and inappropriate, and people in their DIY think they have to follow it. And the trap is by including daycare, you can't get out of that daycare until you modify it, even if the child's no longer using after school care, daycare, whatever it may be. That is the biggest trap on a DIY divorce when you're having child support. And I'm sure you see the same thing in Florida.
I agree. So oftentimes, just like you said, they're lumped into the child support calculation. The only way to get child support to be readjusted is a brand new calculation. What does that mean? A modification, exchange of financial documentation, updates on what daycare exists. Looking into all of that information, it just creates problems. Whereas if we have language in there that says we're either including the daycare in there, but saying we expect the child to age out of daycare at this time, so here's going to be the reduced or the updated child support obligation for the family is going to be listed in there, or we simply carve out. We've also done the daycare expenses since if it's going to be for a short period of time, and say, well, we're going to pay it separately. That way that the child support is not changed, and we don't have to continue to go back to court for these changes that are going to happen because children don't stay in daycare for forever.
Yeah. And I mean, I can say that DIY divorce, the majority that I see means you're going to hire a lawyer sometime in the future. And our point is, if you're going to hire the lawyer, let's make sure we do everything we can to try to prevent that in the future, like that daycare. And similarly, spousal support, maintenance, or alimony, it's called around the country. That one's the big one. You have to be really careful as well, as be specific. If your intent was to only pay a specific amount and it just says $100 a month and it's left there, it's forever until otherwise modified, right? That's a very tricky and dangerous one when you're trying to modify, and you can talk about the standards for modification of alimony too.
Absolutely. Alimony is a huge one for that specific reason that you mentioned, duration. If we're not seeing duration specifically put in the agreement, then it's open-ended. It's forever. So, and it's not easy to change. In Florida, in order to change it, there has to be a change that was unanticipated. So you have to make sure that whatever's in the agreement and whatever you think you can modify with later is already contemplated. One of the things that we see a lot is on long-term alimony obligations is retirement. So someone will not be of retirement age at the time they sign an agreement and say, well, I'll just figure that out when I retire. But sometimes retirement alone is not enough to get you over the hump to prove your burden. So, we try to work in there and we put language in there that contemplates, okay, we're going to pay this amount of alimony obligation for this period of time, but it's already expected and anticipated that people are going to retire. And upon retirement, child support alimony will either be terminated or it'll be reduced because of these reasons. And, sometimes it's very, very, very difficult to get these changed later because of that unanticipated factor in our burden.
Yeah. I want to talk about custody too, because I like to include some language, but before I talk about that, just a reminder, if you have questions, submit them in the Q&A section right now. And I know I've got a couple of questions ready. We're going to be addressing those here in about 10, 15 minutes or so. So do that now and we'll get an answer to you. So as it relates to custody, Amanda, I think I like to include language, and this is something that DIY divorce won't afford you, is I like to include language that sets up why we're agreeing to this type of schedule. A good example is, let's say I have young children and I may not be doing as frequent of custody or exchanges as I want. Maybe I've got under 4 or they're not school age yet. And so I may do less overnights and maybe more quality time. And so I may say that the parties agree to this schedule simply because of the age of the children. And that way that's setting up a standard for a change in the future rather than just leaving it blank and leaving it up to say, well, I don't know why I agreed to this. I'm not really sure. So that kind of language you're not going to find in DIY forms, right?
You're not going to find those in DIY forms. Oftentimes in the DIY forms, it's we agree, and it's a big blank line, and you have to fill in with what you agree with the language that you come up on your own with. So I completely agree. I have a lot of clients that come back and just say, I don't have overnights. I have clients that simply agree to non-overnight time sharing because the child was little at the time that they signed the agreement, and they never put language in there when the child becomes school aged, when they have a more defined structure, and you have pickup time, drop off time, they have after school care activities. None of that was ever contemplated. So now we have to go to court and convince the court that some kind of a substantial change exists. And that's not that easy because the child existed when you signed the agreement. You anticipated the child was going to eventually go to school. You anticipated that there was going to be activities. So now we have to say, judge, we need a modification. We need overnights. And as we know, overnights in Florida tie in directly with the child support calculation. So it all goes lumped in together. If your time sharing is off, your child support is going to be off. So it's very important that, you afford a lawyer an opportunity to guide you and help you through language in these agreements that don't basically prohibit time from you later with your children, or even create a huge litigation to children that are your own that you should have access to.
So what type, as we round out your topic, what type of experts, what kind of evidence, would you need to talk about perhaps changes of custody or even, correspondingly changes of support?
So what I always like to have my clients do is as simple as have a journal of all the time that you have the kids, whether it's overnight or not. Have a list of any support that you've sent to the other side, whether it's obligated or whether it's support that you sent in addition. Witnesses are helpful if you do need to go forward with a court hearing. There are experts such as guardian ad litem, which can be attorneys or psychologists that are involved in the case to investigate if there are time sharing issues there, to be able to provide direct reports and information to the court. Guardian ad litems have direct access to teachers and the children and the parents, people that the court don't necessarily have direct access to. So these guardians are able to do their investigation, put it down on paper, submit a report, and even testify to the court, which can be helpful in a modification action.
Yeah. Well, Jared, let me go to you as I'm thinking about it. And I liken it to this, I think I can do plumbing. So I may cheap out, not hire a plumber, go fix it. But in the end, I've had it where, okay, now it caused a leak. Now I've not only need to replace the plumbing, but I caused damage to the drywall and the studs behind it and the flooring. And so my cheaping out cost me in the long run, where I could have just hired an adequate plumber, someone who's licensed and experienced to do it. The same goes for an attorney. Don't cheap out on the DIY end and cost yourself in the end, right?
Cheaping out on the front end can cost you dearly on the back end. Too many times I meet with clients, they come in for a consultation, or potential clients that they weren't represented at the divorce stage. They've made a deal and they come to me and they say, this isn't fair. And I look at the divorce decree and I agree with them. And I say, it's not fair. But in Mississippi and in many other states, matters that are of property division, such as financial accounts, houses, etc., are never modifiable. But, they just signed it and now they can't do it anything because they did cheap out on the front end and did it themselves. And, had they spent the money to hire an attorney to look over that, they would have been a lot better off financially in the long run, very similar to your plumbing description. Yeah,
and it came to my mind because here I actually tried to do that. And of course I caused water damage to, it is what it is. We all learn. And here I'm telling everyone not to do it. And I did it myself because our natural inclination is to, yeah, I can do it. And gosh, lawyers are expensive, but it is an investment. And typically, someone's getting divorced and they have kids or they're paying some sort of support. the likelihood of them modifying in the future is pretty high at some point, whether it's to their advantage or someone comes after them. And so it's about laying the right foundation. If you're building your home, you're not going to cheap out on the foundation only for the home to collapse in on itself. Spend the money to make the foundation right. And that's what the divorce is. And I think you may have mentioned, I've had guys come in, do a terrible language about property or forget something, or they didn't realize that the language actually gave her his separate property. It's non-modifiable once that's done, right? It's, at least in Missouri, it's that way. Property division as written can't undo it, right?
Not in Mississippi. If it's a matter of property, it's done. Once that's entered, and like I say, most attorneys would not have let them agree to those matters that they did agree on, and they're stuck with it. And I hate advising on them on this, because a lot of times I'll tell them, I wish I had met you back in 2018 or 2019 when you made that judgment. And oftentimes they'll say, well, so do I. And, it's just better to consult an attorney.
Yeah, that's part of I think some of the 10 stupidest mistakes. We're going to do a seminar in Mississippi coming up this next month, so it'll be good. If you want more information, you can go to CordellCordell.com and check it out. It's the 10 stupidest mistakes guys make when facing divorce. It's a great seminar. We're going to be holding it in Mississippi, so check that out. Also, as you think about some of the things, is that many guys are embarrassed to come in for a consult, because they've done something wrong, whether it's adultery, financial misconduct, alcoholism, gambling, whatever, some addiction. It's a very private, very embarrassing moment. And sometimes they just don't do it simply because of that. But isn't that when they need an attorney the most, is when perhaps there's this underlying issue that created the breakdown of the marriage?
Absolutely. When you've done something wrong is when you need an attorney the most. And, when people are facing criminal matters, because they've done something really wrong, they quickly go get an attorney because, they're facing jail time. Unfortunately, though, when people have done something wrong in a family law matter, they want to keep it private, and they do, but they don't even want to go and consult an attorney. And I see this the most common in two scenarios. Number one is maybe they've committed adultery and they want to save their marriage, or number two, they've done something wrong and they just don't want to have that embarrassing moment in the courtroom, or they're scared of what the judge will do. But those are the times that they absolutely need an attorney the most. In the first example, that, whenever someone's trying to save their marriage, I've actually had people come into my office and they've told me that they signed divorce papers because they were trying to keep their spouse happy and save their marriage. I've never understood why you would sign divorce papers when you're trying to save your marriage. It just doesn't make sense. Now, that doesn't mean that the people weren't smart. All it means is that they were emotionally wrapped up in the process and weren't thinking like themselves. And that's the very reason that you need an attorney, somebody that's not emotionally, it's not some super great wise advice to say, don't sign divorce papers if you're trying to save your marriage. But it very well may take somebody that's not emotionally wrapped up in the process to point that out. And if an attorney had just said, don't sign them, they probably would have ended up with a lot better deal. And then on the other side of that, the embarrassing moment where they're scared of what the judge will say when they've done something bad. In my experience, what I have found is that judges see a lot, and most likely whatever you've done or that person has done, these judges have probably seen much worse.
Yeah.
And there's usually an attorney or an opposing party making some super threat against that person of what will happen if they don't sign this. Mm-hmm. And when you're negotiating, when somebody's trying to make you sign something fast or do something fast, that's usually the time to slow down and not do it, because it may very well be a pure bluff. And let's say you do go to the courtroom. Let's say you do have a trial. Okay, whatever you did, it may come out. It very well may be an embarrassing, awful moment, but you would probably be better off to have that embarrassing moment in the courtroom and move on with the rest of the trial and get a better result than you would be if you signed some silly agreement that would affect you for a very long time that you probably can't undo.
Yeah, I totally and completely agree with you. And judges have seen, most of them have been in family law for enough time that they've pretty much seen and heard everything. And I've always tell clients, especially in the seminars that we do at night, look, I've been doing this for 28 years, probably longer, it seems like, and I've seen it all. And there isn't anything that I haven't dealt with. And there isn't anything particularly that I can't deal with, unless it's, child abuse, right? And that's always the difficult one to try to navigate through. But adultery, I don't care. Financial misconduct, don't care. Whatever it may be, it's about getting someone to put you in the light that makes it look normal, even though it's misconduct, and making sure that you look before the judge as repentant. And, that bad conduct isn't as bad as you think it is, as you suggest. And I think that DIY divorce can hammer you. And we'll talk about that, and even representing yourself in pro se with Megan here in a minute. But, that moment embarrassing in front of a lawyer doesn't mean that, one, you have to get divorced, or two, you have to go to trial, right? I mean, meeting with a lawyer is just like this. You signed up. There's a bunch of you watching right now. Simply doesn't mean you've got to go file for divorce or you've got to go to trial. It's about learning and educating yourself, right?
Well, not only does consulting a lawyer not mean that you have to get divorced, but even if you start divorce proceedings, I mean, I've had a lot of people that we've been on the eve of trial, and they've reconciled and they've saved their marriage. But when that's happening, that is not the time to take the ostrich defense and just put your head in the sand. Because if you don't participate in the process, you're most likely going to get divorced, and it's going to be on bad terms. And no, meeting with an attorney definitely doesn't mean that you have to get divorced. And on that note, Mr. Trout, I would point out one thing that's unique to Mississippi is a lot of times, if you want to save your marriage and you do go all the way through and get divorced, in Mississippi, you don't have to get remarried. We actually have undivorced in Mississippi. There is a statute to do that in the event that it happens. Now, it does take a full reconciliation, but I don't know how many other states have that. But meeting with an attorney does not mean that you have to get divorced. Yeah,
so unique. I've not heard that. It is, I mean, I guarantee I've never seen a DIY form of undivorce either. And so again, what a great snippet of information you're going to get from a lawyer who's been doing this a while. And that honestly, it's why I hate maybe WebMD, and that we have a lot of pseudo doctors out there that go to WebMD and they're like, they diagnose themselves. Well, yeah, that's what I've got. I've got COVID. And you don't have COVID. And you take steps based upon what you think you know. And whether you just go in for that 1 hour consultation with a doctor or a lawyer, it's the best money you're going to ever spend. And you walk out with really good knowledge. So thanks, Jared. So Megan, let's talk about, which is a very common situation where parties go in without lawyers, and then they can't agree. And so now they're in court. So are they held to the same standard as lawyers? What are the problems and pitfalls with a DIY divorce when neither party has a lawyer?
Yeah, that's a great question. I did want to just touch really quickly on what Jared had said as far as that embarrassing information. And it kind of plays into what happens when you get to trial or court. The embarrassing information is going to come out because that is the other side's kind of big moment to, the smoking gun in a sense. And so having an attorney helps you with what I like to refer to as a lean into the skid kind of approach, where you're able to present that information, where you take accountability when needed, but you're also able to show things like change and repentance and remorse. And so I think that's really helpful, and that's really challenging to do without the right perspective. If it's just me going in for myself, I have emotional ties to that issue, which has already been talked about today. And so having an attorney, I think that's a really important step to it. Once you do get to a hearing or get to trial, here in Nebraska, I don't know about every other state, but in Nebraska, pro se litigants, unrepresented parties are held to the same standard as if they were represented. And so you don't get special treatment. You don't get hints from the court. You have to know the rules of evidence. You have to know the rules of procedure. You have to know how to object, when to object, what to object, and nobody's going to tell you what to do there. And so if you're at the point where you're at trial, It's really important to have an attorney that can help you keep the right information in and keep the right or the wrong information out.
Yeah, and it's even evidentiary objections, whatever it may be. You're held to that standard, and you need to know. And I guarantee you don't know. There are many lawyers that don't know, and it's difficult enough as it is to know the process, the procedure. Each court may have its own process. I practice in Georgia, which I always have a great story, and it's very different than Missouri and Illinois. My first time there, here I'm a lawyer. You normally have a court reporter who takes the notes and writes them down and swears the witness in to tell the truth and nothing but the truth. Here in Georgia, I'm getting ready to try my first case, and everyone's quiet and I'm waiting for someone to swear the witness in. Well, I didn't know the lawyer's supposed to swear the witness in. Who knew? I guarantee you, it's a classic example of my DIY divorce in my first time in Georgia. I didn't even know, much less an objection was made that dog won't hunt. Mississippi probably knows what that means, but I didn't know what that dog won't hunt. That's not an evidentiary rules that I learned. But the point is that you will be held to that standard and you will pay. You'll pay dearly. And it's so difficult, much less every county. I just did a podcast on this. Every county, perhaps in every state, has local rules related to maybe standing orders, timelines, time to answer, what your discovery limitations are. Litigants who are pro se are going to be held to the same standards of timeline, and they need to know where to look, and they may not know, right?
Yeah, absolutely. I mean, here in Nebraska, we have Nebraska rules. We have district court rules that go for every district court. Every individual district then has their own set of rules. You can have different rules by county. You can have different rules by judge. And then I mentioned earlier, I practice in Ponca Tribal Court. Ponca Tribal Court has a completely different set of rules, including rules of evidence, because they are sovereign. And so there's completely different rules there. And there are, in Nebraska, there's 90 something counties. And so to be able to know exactly which rules apply to your situation, even where to find the rules, and you have to know the rules all the way down the board. You can't just say, okay, I'm going to look for this judge's rules, because you also have to comply with the district and the county and the state ones. In addition to that, we've got case law that comes out in Nebraska that isn't captured in any rules, and you have to comport with that as well.
Yeah, I know Missouri, they just handed down changes to discovery that lawyers get notified, and it's probably buried somewhere in an email or media release that DIY litigants would never see. And let's just say you do it, now you're in violation of the rules. Maybe you're going to get sanctioned by a cranky judge. You may get your pleadings struck or dismissed. I'm telling you, there's so many pitfalls in a DIY divorce when you're doing it yourself. And it's worthy of just coming to have that conversation. We talked about consultations. And believe me, I'll convince you to never do a DIY divorce. At least have an attorney review those things, because deadlines are key. Forms are key. That you just like I said with Andy, Megan, you and I could talk for an hour on some of the things about pro se litigants in court, about being held to a standard. There's a reason you go through law school for 3 years, and there's a lot to learn, and especially with civil procedure. The judge is not going to be afraid to hold you to that standard. May reference, what's Rule 5503, sir? And you're sitting there, I have no clue, right? So anyway, thanks for giving that information, Megan. Let's get to, and I know we've got some questions that are submitted already, and we're going to turn to that right now. We have some time to go through it, so let me pull those up real quickly here. So let me toss this right back to you, Megan, just since you and I were just talking. MH has a question about wife claims she works part-time, but I'm certain she's actually full-time. How do I either prove she's full-time? How do I prove that she can work full-time? What do I do to get wages? Where am I looking? And I know we had a podcast on this, or a virtual town hall on this subject, because there's this, road and fields, or I can't remember, all this online stuff is happening where you may be working in cash, getting it via PayPal or Venmo, hard to trace information. But MH just wants to know, how do I prove she's actually working full-time, or perhaps capable of working full-time?
Right. So I know here in Nebraska, we would look for formal discovery in order to get that information. And it's really a matter of knowing or having an idea of maybe where that is coming from. And sometimes we have to trace it back. If we don't know where somebody's working, then we're looking at bank records and being able to, if you hired an attorney, they'd be able to help you with getting bank records subpoenaed. There are different rules for how to obtain those. You can't just call the bank and ask for it. And so being able to subpoena those documents so that you can try and figure out and then look for more information afterwards, especially if somebody is not being forthcoming with how much they're working or where they're working. Sometimes you have to kind of fill in the gaps and do a kind of a dot to dot with that.
Yeah, I mean, I agree. It takes a little bit of work from the lawyer's perspective. I mean, there are a lot of opportunities if we know where she works and she's saying, oh, I'm only working 10 hours. Now we get the employer involved. We subpoena records. You talk to friends. You look at bank account records. You look at emails because I'm looking for Venmo transactions because when you get a Venmo, you get an email. Look through that, the deleted section. Look at PayPal records. You're really just kind of doing this forensic evaluation, looking for clues that may indicate. Because remember, from a judge's perspective, when you're, MH, is that I just have to kind of make it past the sniff test. If a judge thinks you're working full time, but I don't have to necessarily prove it all the way, that may be just enough to upset the judge. Now you still have to have concrete proof to establish income. But what my goal and our goal is to maybe raise some credibility issues, and that really matters a lot. So thanks, Megan. Andy, Dave has a question, albeit it's from North Carolina, but I think we can answer this. And North Carolina particularly uses the words equitable distribution. And I think what that means, and I'm curious about Minnesota, particularly since we don't have one of our attorneys from North Carolina, in terms of dividing property, well, we talk fair, reasonable, not unconscionable is the language we use in Missouri. So maybe that's what I imagine equitable distribution means in terms of dividing property. And what's the standard in Minnesota?
Minnesota, the standard would be equitable division.
Mm-hmm.
And equitable division means fair, whatever that is. That could be something less than half and half, something more than half and half, kind of depending on the specific situations of the case, is what Minnesota standard is. That's distinguishable from Wisconsin standard, which is a community property state,
Mm-hmm.
which essentially means that everything is divided equally. An equitable division can take into account things like assets that were acquired prior to marriage, things that you have by gift or inheritance. They may not be divisible. I don't know specifically what North Carolina law is, but equitable division gives a little bit of flexibility in determining what equitable is. It doesn't have to be it doesn't have to start out from a presumption of strict half and half,
Right.
which a community property state would do.
So yeah, equitable it's really, they use these big words and I hate it. This fair, reasonable, and not unconscionable, and equitable, like not shocking the conscience. Doesn't, like, there is some case law in Missouri that says a 90-10 division of property, 90% to wife, 10% to husband based upon conduct is fair, is equitable. So who knows? I mean, it's case laws driven, right?
Well, I agree with that. I mean, I can think of a case where I had someone going to prison.
Mm-hmm.
And, equitable in that situation was one spouse got everything and the other got nothing.
Yep.
So it's really a fact-driven situation. So
It
in
is.
your case, it might not be a half and half. It might be something different based upon conduct of the parties. I mean, that's something that can factor in. Marital misconduct technically isn't always a factor, but how things are looked at is really a case-specific driven thing. Is an equitable as long as the judge generally has a reason.
Mm-hmm.
That is going to be upheld. And as long as that reason makes some sense,
Yeah.
there's no court in the land that's going to probably overturn that.
All right, Amanda, I've got a question that comes in a little bit long, so I'll walk you through, but here we are. Mother contracted COVID shortly after the divorce was granted in December of 2020. She kept the kids away from father, claiming quarantine through Christmas. Thereafter, she claimed one of the kids was sick, and thereafter wouldn't let father know the progress and never did update. Fast forwarding to April of 2021, she filed for a termination of shared parenting, which is every other weekend, Friday through Monday. I guess wrapping in the idea that maybe COVID and those types of things. So what are your thoughts from a Florida perspective in terms of the change and the standards for custody? What we basically have is mom had COVID, maybe child had COVID, wouldn't let kids see dad. There was really no update in legal custody in terms of how they were doing. And then out of the blue, 4 or 5 months later, she looks to change the shared parenting, which is every other weekend, Friday through Monday.
I remember when we did something along the lines of COVID and time sharing last year, when this was starting to come up. So in Florida, the courts were pretty along the lines unanimously along the different counties that I have experience in, that they were enforcing time sharing orders. So if someone were to have contracted COVID and there was going to be exposure to the children, then for that period of time until that person got better, then there might have been a little lapse with the idea that that time could be made up in the future. But for the most part, the courts weren't allowing parents such as this mom to use COVID and anything associated with COVID to keep the other parent from having time with their children. Again, we have modification standards and we have what you need to prove in order to terminate this time sharing plan that she's wanting to do based on the last couple of months, from my understanding, based off COVID. And she may not be successful using that when it was her actions that kept the other parent from seeing the children, from my understanding. So I think that this is one of those cases that you have to get in front of the judge on. You have to fight for the kids. And not only do you fight for the time sharing that is in place, right, to enforce it, but you also fight to make up the time that you lost based on her behavior.
Mm-hmm. Yeah. And I think, that substantial change in circumstances unknown at the time of the decree is key. Maybe she had COVID at the time she signed off, and that's, signed off on this shared parenting schedule. The judge is looking for something different and unique. What's changed in 4 months? My guess is nothing, unless there's a significant allegation of abuse or neglect, or maybe the children are, reacting well, but it seems like a dead motion to me, but it's definitely worth coming in, having a conversation. Let's take a look at the decree. Let's see if there are any particular or peculiar provisions, and then we can kind of give you the direction on the law and maybe even that judge and what they're likely to do. So it's a good question. So Jared, let me go to you. This is Dan from Alabama. My ex and I went through a divorce about 2 years ago. We have a parenting plan in place where I get the kids 2 weekends each month. And she has them during the work week, every week. And then sometimes this individual travels, although they haven't much over the last year because of COVID. Now that vaccines are available, I'll be traveling for work more, and she's concerned of me being around the kids after traveling, and is now trying to modify the agreement, kind of what Amanda and I were just talking about, to say I can only have them the weekends I don't travel. I plan to get a vaccine, and this is not fair. Should I get a lawyer now to make sure that doesn't happen? What is my first step, Jared?
You're right. This is very similar to the last topic. And what the Mississippi courts have done with this is they've said that travel for purposes of visitation is an essential activity, and not just travel, but also, they want these custody orders to be followed. And my advice would be, yes, you should consult an attorney. And if that fact pattern were here in Mississippi, what you would do is you would file a contempt or enforcement action to enforce that decree. And, based on just the facts that I know there, you may get attorney's fees on that, because you cannot, COVID, I like to say it like this: COVID-19 is not a good reason to be a bad parent to the other parent. You cannot use that as an excuse to keep the non-custodial parent away. Now, certainly, if you think you've tested positive, or you may think you may have it, certainly stay away. But just because you haven't gotten the vaccine yet, you need to be getting that time with your children, because if you don't, you run the risk of other things, such as establishing a pattern of not exercising that visitation, and that can really negatively impact you in other ways. So you definitely need to go ahead and consult a lawyer and start getting that visitation, and start getting it now. And most likely what happens in that scenario is, as soon as you hire a lawyer and they write a letter, you probably will start getting that visitation before you ever have to go to court.
Yeah. I'm beginning to see a couple things now. Refusals are DTC, due to COVID, and these excuses not to provide custody or to make a change are convenient. I'm going to trademark that, convenient, because it's just ridiculous. I've been using that lately. Judge, that's convenient. And they get it. And that's the point. They're using a pandemic to create a reason or justification that is really not founded in the law, and there's really no reason to do it. And it is convenient. So thanks, Jared. All right, let's go to, let me look here, Megan. Megan, Morgan from Colorado asks, my ex has 2 retirement plans, one regular pension and one 401k. He started the 401k before we were married, and I believe he's accrued a good deal of money in it, but won't tell me directly how much. Is there anything I can do to make sure it is valued and split properly during the divorce?
That's a really good question. And that is another one that really depends on what state that you're in, what rules apply. I only know what the Nebraska rules are. And as far as getting that information, especially if somebody's not being forthcoming, or even if they are providing information, but you're not sure if it's everything that you need, that's when an attorney can help you do formal discovery. I talked about it a little bit earlier, and that is knowing how to get the statements. What statements need to be provided? If statements are not provided, they can help you get in front of the judge to make them provide those statements, as well as any applicable sanctions. I would say consult with an attorney, so somebody that knows the laws, what the split should be. Because I know here in Nebraska, we've got premarital property. There's certain things that you need to prove in order to keep it. There are different rules as far as the growth on that account, whether it's premarital or separate, or if it's part of the marital estate. And that's very case specific, as well as state specific.
Yeah, it is state by state. Even in Missouri, you're looking at, even if something like a 401k was created prior to the marriage, but then there have been contributions subsequent and during the marriage, you're looking at basically a fraction. It's a number of months married over then the top number is a number of months, number of months employed in there, and number of months married. You're getting a fraction of how much of that is marital. It's a really straightforward, but getting a subpoena out, finding the value, and it depends if it's a defined benefit or whether or not it's a contribution type pension. There's a podcast we did, and you'll find it on our YouTube channel, about the differences. There was a 2-part series. The differences in a defined benefit and a contribution pension. When you give money to your 401k, that's kind of contribution. A defined benefit is, for example, you may have a union worker who doesn't contribute money, but it's based upon maybe 3 years of their highest salary, and there's a specific dollar amount. That gets a little bit more complicated, so it's worthy of a subpoena to figure that out. So let me go to Andy. Andy, David in North Carolina asks, I live in North Carolina. We've been separated for 3 months. I owned a home in Illinois, which I bought in 2010 before we were married. She moved in 2011. Then we didn't get married until 2015. So bought it in 2010, married in 2015. I semi-retired at the age 55 in 2017 and received a severance. I used the severance to use a down payment on the house in North Carolina. She is not on the mortgage or on the North Carolina house. I sold the Illinois, it gets complicated. I sold the Illinois house in 18 and banked the money. We have separate bank accounts. Since she's not on the mortgage, what assets is she entitled to? So it's really about that house that looks like it was acquired at some point, let's see, in 2010, she moved in and they got married. So there was a house before the marriage that he had. So that's really the question, I guess, is in regards to that Illinois home.
I'm not sure exactly what North Carolina law, I learned it was equitable division. So I suspect, from the earlier question, I suspect this has non-marital interests. In Minnesota, generally non-marital interests can be set aside for the person who had a non-marital interest. And non-marital interest is something acquired prior to or by gift or inheritance during the marriage. And the key to it really is you have to trace it. So we would have to trace what all happened with this Illinois house, what investments were made, and then you could figure out what a non-marital share would be. So typically what I would suggest is you would want to hire an attorney, and then we likely would hire some sort of accountant to help us do the tracing so you could do the math, and that could be a significant amount of money. And in Minnesota, it's a percentage. So for instance, if you were able to trace a percentage and you determine like 15% was non-marital, and then you apply it to the value of the house now. So if the house is worth $100,000, So 15% times 100,000, that means 15,000 is set aside just for you. So and I think the same probably applies to separate bank accounts. This seems like a case that's really important to see an attorney so you can kind of do some of these non-marital tracings, because it is possible that some of these assets could be segregated.
Yeah, and it is, it's a premarital property, something, purchased before can in itself have a marital component depending upon the state. If you're paying taxes out of marital earnings, you're paying the mortgage out of marital earnings. So there's some sort of component there that transmutes it into a marital component. It's unlike, let's say you have a rental property in which you own it outright and you don't commingle it with any marital money. You only use the income to pay the taxes, whatever it may be. It's very different and unique. There are some states, surprising to find out, I can't remember, it was one of our podcasts, where the marital property is defined as of the date of separation. So everything after separation becomes separate property. Really unique. So really, we have an office in North Carolina. Certainly encourage you to check in there. We have multiple throughout the state. So I encourage you to check in with a lawyer there. So our last question that we have time for, we'll go to Amanda. And I know I'm going to answer a little bit of this and I want your thoughts because it's complicated. My wife is a business owner with 4 locations in 3 states. She's 50-50 partners with someone else. They use some money to start the company, some marital money in equal parts. She handles many aspects of the business, including bookkeeping and accounting. She has slowly repaid the startup capital. So it kind of looks like she's a slow payback. She gives herself about $1,500 a month. He pays all the expenses out of their joint account for that company. I'm not certain, but I believe her partner has been taking a decent salary, but she has not. The question that James has is, would a forensic accountant be able to determine whether she's underpaying herself and our 50-50 partnerships bound by equal compensation? And so let me answer this, and I want your thoughts, Amanda. Obviously, forensic accountant, I'm very familiar right now. I'm in the middle of a case very similarly where we hired a forensic accountant to do an analysis to determine, one, is the owner underpaying themselves, or 2, are they paying themselves by using the company credit card? And they also have a 49% owner. And should they be paying themselves more than the 49% owner is taking? And so that's really the question that's out there that an accountant absolutely should and could answer for you. It's not something that we would be able to competently do that. That's why we would retain an expert. I've done that. And Amanda, I'm just curious as your thoughts.
Absolutely, 100%. So the role of a forensic accountant is to provide litigation support and to investigate. So when you have someone who's running a company and like she is in this specific case and paying herself out, but then he's paying the joint expenses, we need to divide those two things. We need to see what's going on the company end, and then what's going on the personal end to see if there's any kind of tie with the company. All of that goes back to their incomes, to the wife's incomes. Like you were saying, is she underpaying herself? But is she underpaying herself salary, but yet using those credit cards to reduce her personal expenses, which then can then be tacked on as her income? So, the role of these forensic accountants is to do this. It's what they do. They're the experts. They're the ones that have the knowledge. And we rely on them. And not only that, they're also able to articulate to the court what their findings are. So, there's a lot of lingo that forensic accountants use or regular accountants use, and we're all able to explain it. But to explain it to a judge that may not have the knowledge of the particular facts in this case is very essential for the judge to have the information to digest it and to make a ruling on the matter.
All right, that's all the time we have. Thanks, Amanda. I appreciate it. And thanks everyone for joining to our virtual town hall this month. We look forward to next month, but in interim, if you have questions we couldn't get to, submit those to townhalls@cordelllaw.com. Townhalls@cordelllaw.com. Tune into our podcast twice each week. Subscribe. You'll get alerted when a new one's been dropped. Check out all of our information, all of the resources, all of the recordings and podcasts and town halls on our YouTube channel. Check us out on social, on Facebook, and also just go to CordellCordell.com and give us a call. We're happy to have a meeting with you, a consultation at 866-DADS-LAW. So until next time, and see you at the next virtual town hall, have a great rest of the week.